expect them to be back on the floor at about 2:15 Eastern. Also, we have cameras on Capitol Hill to get remarks from lawmakers as they lead their lunches. We expect those remarks at about 2 p.m. Eastern. We'll join them live. Much of the debate today in the Senate is centered on an amendment brought by Colorado Senator Mark Udall related to the defense programs and policy legislation. His amendment will remove detainee provisions from that bill and require congressional hearings with Pentagon officials and the administration on how to handle terrorism suspects. A vote on that amendment is expected this afternoon, shortly after senators return to the floor. Well, an article in The Hill today captured some of the action on the floor and exchanges between Republican Senators Rand Paul and John McCain. Senators Paul of Kentucky and McCain of Arizona battled on the Senate floor today over a proposed amendment to the pending defense authorization bill that could allow American citizens who are suspected of terrorism to be denied a civilian trial. Senator Paul argued that the amendment, which is co-sponsored by Mr. McCain, puts every single American citizen at risk and suggested that if the amendment passes, the terrorists have won. Should we err today and remove some of the most important checks on state power in the name of fighting terrorism, well, then the terrorists have won. Mr. Paul argued detaining American citizens without a court trial is not American. You can read the rest of the article by Josiah Ryan at thehill.com. While we wait for senators to return, here's a bit of the re-air of that debate.
Mr. President, James Madison, the father of the Constitution, warned, "The means of defense against foreign danger historically have become instruments of tyranny at home." Abraham Lincoln had similar thoughts, saying, "America will never be destroyed from the outside. If we falter and lose our freedoms, it will be because we destroyed ourselves." During war, there have always been a struggle to preserve constitutional liberties. During the Civil War, the right of habeas corpus was suspended. Newspapers were closed down. Fortunately, these rights were restored after the war. The discussion now is to suspend certain rights of due process is especially worrisome, given that we are engaged in a war that appears to have no end. Rights given up now cannot expected to return. So we do well to contemplate the diminishment of due process, knowing that these rights that we give up now may never be restored. My well-intentioned colleagues' admonitions in defending provisions of this defense bill say that we should give up certain rights, the right to due process. Their legislation would arm the military with the authority to detain indefinitely, without due process or trial, people suspected of an association with terrorism. These would include American citizens apprehended on American soil. I want to repeat that. We are talking about people who are merely suspected of terrorism or suspected of committing a crime and have been judged by no court. We're talking about American citizens that could be taken from the United States and sent to a camp at Guantanamo Bay and held indefinitely. This should be alarming to everyone watching this proceeding today, because it puts every single American citizen at risk. There is one thing and one thing only that is protecting American citizens, and that's our Constitution, the checks we put on government power. Should we err today and remove some of the most important checks on state power in the name of fighting terrorism, well, then the terrorists have won. Detaining citizens without a court trial is not American. In fact, this is an alarming, arbitrary power that is reminiscent of what Egypt did with its permanent emergency law. This permanent emergency law allowed them to detain their own citizens without a court trial. Egyptians became so alarmed at that in the last spring that they overthrew their government. Recently, Justice Scalia affirmed this idea in his dissent in the Hamdi case, saying, "Where the government accuses a citizen of waging war against it, our constitutional tradition has been to prosecute him in federal court for treason or another crime." Scalia concluded by saying, "The very core of liberty secured by our Anglo-Saxon system of separated powers has been freedom from indefinite imprisonment at the will of the executive." Justice Scalia was, as he often does, following the wisdom of our founding fathers. As Franklin wisely warned, Those who give up their liberty for security may wind up with neither. And really, what security does this indefinite detention of Americans give us? The first and flawed premise, both here and in the badly misnamed Patriot Act, is that our pre-9/11 police powers were insufficient to stop terrorism. This is simply not borne out by the facts. Congress long ago made it a crime to provide or conspire to provide material assistance to Al-Qaeda or other foreign terrorist organizations. Material assistance includes virtually anything of value: legal, political advice, education, books, newspapers, lodging, or otherwise. The Supreme Court sustained the constitutionality of this sweeping prohibition. We have laws on the books that can prosecute terrorists before they commit acts of terrorism. Al-Qaeda adherents may be detained, prosecuted, and convicted for conspiring to violate the material assistance prohibition. In fact, we've already done this. Jose Padilla, for instance, was convicted and sentenced to 17 years in prison for conspiring to provide material assistance to Al-Qaeda. The criminal law does require and can prevent crimes from occurring before they do occur. Indeed, conspiracy laws and prosecutions in civilian courts have been routinely invoked after 9/11 to thwart embryonic international terrorism. In fact, from the Bush administration, Michael Chertoff, then head of the Justice Department's Criminal Division and later Secretary of the Department of Homeland Security, testified shortly after 9/11. He underscored, "The history of this government in prosecuting terrorists in domestic courts has been one of unmitigated success, and one in which the judges have done a superb job of managing the courtroom and not compromising our concerns about security and our concerns about classified information. We can prosecute terrorists in our courts and have done so. It's the wonderful thing about our country is that even the most despicable criminal, murderer, rapist, terrorist, our court systems do work. We can have constitutional liberty and prosecute terrorists." There is no evidence that the criminal justice procedures have frustrated intelligence collection about international terrorism. Suspected terrorists have repeatedly waived both the right to an attorney and the right to silence. Additionally, Miranda warnings are not required at all when the purpose of the interrogation is public safety. The authors of this bill errantly maintain that the bill would not enlarge the universe of detainees, people held indefinitely. I believe this is simply not the case. The current authorization for the use of military force confines the universe to persons implicated in 9/11 or who harbored those who were. This new detainee provision will expand the universe to include any person said to be part of or substantially supportive of Al-Qaeda or Taliban. But remember, this is not someone who's been concluded at trial to be part of Al-Qaeda. This is someone who is suspected. If you are a suspect in our country, you are usually accorded due process. You go to court, you're not automatically guilty. You're accused of a crime. But we're saying someone accused of a crime could be taken from America's soil. An American citizen accused of a crime, a suspect of a crime, could be taken to Guantanamo Bay. These terms are dangerously vague. More than a decade after 9/11, the military has been unable to define the earmarks of membership in or affiliation to either Al-Qaeda or other terrorist organizations. It's an accusation and sometimes difficult to prove. Some say that to prevent another 9/11 attack, we must fight terrorism with a war mentality and not treat potential attackers as criminals. For combatants captured on the battlefield, I agree. But these are people captured or detained in America, American citizens. 9/11 didn't succeed because we granted terrorists due process. In fact, 9/11 did not succeed because Al-Qaeda was so formidable, but because of human error. The Defense Department withheld intelligence from the FBI. No warrants were denied. The warrants weren't even requested. The FBI failed to act on repeated pleas from its field agents who were in possession of a laptop that may well have had information that might have prevented 9/11. But no judge ever turned down a warrant. Our criminal system didn't fail. No one ever asked for a warrant to look at Moussawi's computer in August, a month before 9/11. These are not failures of our laws. These are not failures of our Constitution. These are not reasons we should scrap our Constitution and simply send people accused of terrorism to Guantanamo Bay, American citizens. These are failures of imperfect men and women in bloated bureaucracies. No amount of liberty sacrificed at the altar of the state will ever change that. A full accounting of our human failures by 9/11 Commission has proven that enhanced cooperation between law enforcement and the intelligence community, not military action or not giving up our liberty at home, is the key to thwarting international terrorism. We should not have to sacrifice our liberty to be safe. We cannot allow the rules to change to fit the whims of those in power. The rules, the binding chains of the Constitution were written so that it didn't matter who was in power. In fact, they were written to protect us and our rights from those who hold power with good intentions. We are not governed by saints or angels. Occasionally we will elect people, and there have been times in history when those who come into power are not angels. That's why we have laws and rules that restrain what the government can do. That's why we have laws that protect you and say you're innocent until proven guilty. That's why we have laws that say you should have a trial before a judge and a jury of your peers before you're sent off to some prison indefinitely. Finally, the detainee provisions of the Defense Authorization Bill do another grave harm to freedom. They imply perpetual war for the first time in the history of the United States. No benchmarks are established that would ever terminate the conflict with Al-Qaeda, Taliban, or other foreign terrorist organizations. In fact, this bill explicitly says that no part of this bill is to imply any restriction on the authorization of force. When will the wars ever end? When will these provisions end? No congressional view is allowed or imagined. No victory is defined. No peace is possible if victory is made impossible by definition. To disavow the idea that the exclusive congressional power to declare war somehow allows the president to continue war forever at whim, I will offer an amendment to this bill that will deauthorize the war in Iraq. We're bringing the troops home in January. Is there any reason why we should have an open-ended commitment to war in Iraq when the war is ending? If we need to go to war in Iraq again, we should debate on it and vote on it. It's an important enough matter that we should not have an open-ended commitment to war in Iraq. The use of military force must begin in Congress. Our founding fathers separated those powers and said that Congress has the power to declare war, and it's a precious and important power. We shouldn't give that up to the president. We shouldn't allow the president to unilaterally engage in war. Congress should not be ignored or an afterthought in these matters and must reclaim its constitutional duties. These are important points of fact.